ready to call the case of Commonwealth versus Parker?
We are, Your Honor.
Okay. And to the media personnel, the buttons that we have to press to turn on the audio are all in place? Okay, thank you. All right, so we are calling the case of Commonwealth versus Parker. For the record, let it reflect the Commonwealth attorney is present, Mr. Jenkins, with Ms. May. Good morning to you both.
Good morning.
The defense is present, Mr. Rogers and Mr. T. Good morning to you both.
Good morning.
The defendant is present, Ms. Parker. Good morning to you both. We rested yesterday. Is there anything you need to address this morning?
Yes, Your Honor, I have two matters.
Okay, yes, sir.
The first is that the court yesterday, as I understood it, we agreed to admit the full and unredacted interview between Dr. Parrish and Dr. Parker. I needed time to just place that on a USB drive. I have done that. It's on Madam Clerk's counter there. I understood at the time that the court had admitted it, and I just needed to provide it. But if the court had not admitted it at that time, I am moving to reopen and admit it as Commonwealth 6.
Any objections?
Not any objections to reopening for the purpose of admitting that.
That's it.
Okay, so great. Commonwealth is reopened, and we will admit it. Does Madam Clerk have it now?
Yes, it's
Okay.
right there.
All right, and this would be 6, Madam Clerk?
Yes, ma'am.
Okay, so admitted, and again, this is just the full video of what's already a redacted version in evidence. Okay, and now that that's done, do you rest again, Mr. Jenkins?
Yes, we rest the reopened case, yes.
Okay, and the second matter?
The second matter, Judge, is just as a preliminary matter. I understand that the defense, pursuant to their own subpoenas, intends to call as their witness several witnesses that have already testified, including Ms. Zwerner, Ms. Kovac, Ms. Parrish, Ms. West, perhaps others. And I just want, as a preliminary matter, to point out Jones v. Commonwealth 2023 VA Act, Lexus 294, decided May 16th of 2023, which holds that it is not proper for the defense to do any impeachment when it calls its own witnesses. And so I am asking the court to instruct the defense not to do any impeachment and not to recross on matters that they already had a full opportunity to cross on. But I certainly would not object to them eliciting new evidence in their client's favor from those witnesses. But in terms of recrossing witnesses they've already crossed, that would not be proper to hear pursuant to the defense subpoena. So I wanted to raise that issue to the court.
Yes, sir, thank you. Response?
Yes, Your Honor. We would be asking, in the event of calling these witnesses, that they be, that we be able to examine them as hostile witnesses.
Okay. And so ultimately, we will cross that bridge when we get to it. You all are entitled to call whatever witnesses you wish, and if they meet the qualifications to be declared hostile or adverse and be treated accordingly by impeaching and or leading questions, then if they meet that statutory criteria, then that'll be allowed. So Mr. Jenkins, I understand your objection now, and it'll be ongoing, and when we get there, we will address it. But again, if they meet the criteria for being a hostile witness, the court will allow them to be treated as such.
I understand. Thank you.
All right, thank you. Okay, so with the Commonwealth resting, defense asked to prepare, time to prepare their motions to strike, and we'll start with them this morning. Are we ready for that?
Yes, Your Honor.
Okay, I'm ready. Please proceed.
Your Honor, the Commonwealth has filed 8 indictments for felony abuse and neglect of children. I'm did not present the names of 8 individual children that were in class that day. They presented no roster or role that was confirmed by any employee that was on staff that day. And more importantly, the Commonwealth is required, I'll just read the jury instruction. In this charge of the crime of child abuse and neglect, Commonwealth must prove beyond reasonable doubt due to the following elements of evidence. And I know at this point where it's the likely suitable to the defendant was a parent, guardian, or other person responsible for the care of whoever these children are, these unnamed children, and that these unnamed children, this unnamed child or children are or were under the age of 18. There was no testimony that any individual child that was present in the classroom by name was under the age of 18. Also, the Commonwealth has to prove that the defendant's willful act or omission in care of whoever these unnamed children are was so gross, wanton, and culpable to show a reckless disregard for human life. Jury instruction that discusses the definition of willful says, a willful act is one done with a bad purpose or without justifiable excuse or without ground for believing it is lawful. A willful act is intentional or knowing or voluntary as distinguished from accidental. In terms of that purpose or without justifiable excuse require knowledge that particular conduct would likely result in injury or illegality. Your Honor, in my own words, the Commonwealth has to establish that Dr. Parker knew, and her response was, so what? I know that there's a weapon and that there's a likelihood that children will be harmed by that weapon or firearm, and I don't care. Let whatever happen is going to happen. There was no evidence that was Dr. Parker's response to anything that happened on that day. She was brought limited information, and she responded to the information that she had. Again, I asserted at the very beginning of this, if we look at the behavior of everyone that had contact with JT on that day, they did not believe that there was a firearm. They did not believe that there was a weapon. There was testimony from Zwerner. She was the person that had the most direct contact than anyone on that day. Her behavior did not indicate that she believed that there was a weapon. She left JT in the classroom. She left other children in the classroom. Then we go to Ms. Kovac. Again, she sat with him, had her eyes on him, watched his behavior. She said it was weird, but her actions in no way indicated that she believed that there was a firearm in possession of JT. And then we consider what Mrs. West testified. She said there were some concerns. She actually observed JT on the playground with the other children. Based on her observations, she was satisfied that there was no weapon. And she only became concerned again when there was a report almost contemporaneously with the shooting that there in fact was a weapon. And then we consider the testimony of Mr. Rawls. He had a lot of contact with JT leading up to this event. On the day of the event, concerns were brought to him. He investigated, put his eyes on JT, was satisfied that JT did not present a danger of harm to the students in the classroom. Your Honor, based on the information that Dr. Parker had, she made decisions. In hindsight, those decisions actually were determined not to be the correct decisions. But that wasn't her decision wasn't an act of neglect. There was no bad purpose, obviously. She didn't intend any harm to the students.
Commonwealth is required to prove is actually what is in the indictment. And what's in the indictment is being a person responsible for the care of students under the age of 18 at Richneck Elementary School. So there's no need for us to prove that they were in the classroom necessarily, though certainly victims, we would argue, are in the classroom, but only at the school. That we did not present specific names is not required. The requirement of the statute is that a person responsible for the care of a child under 18, willful act of omission was so gross, wanton, and culpable as to disregard human life. The statute defining what must be included in an indictment does not include a victim's name. And we can think of common examples of indictments that sometimes don't. For instance, did assault and batter another is a very common indictment that does not include any victim's name. So the jury would, the way it is indicted now, be free to find up to the number of victims that they believe existed, in this case with a maximum of 8. And certainly no indictment can be returned twice for the same victim, and that can be explained to them. But at the end of the day, the jury is the fact finder, and they can decide whether what number of victims there were, if any. And so we think it is inappropriate to try to narrow that to specific names, but rather that the jury can decide based upon the evidence that they have how many to return or to return none. I'm sorry, how many to find guilty on or to find not guilty on all. Given that the argument generally being we didn't prove there were victims, I think that's definitely false. Children, specific children were referred to, 5 of them by my count are R, S, D, G, G, M, G, and K, S were the specific children that we referred to during the course of the trial.
Ms. Jenkins, if you go with the initials one more time, I have S, D, G, G, M, G,
K, S, and R, R.
Thank you.
So we have a total of 5 children that we identified with specificity, but I'll point to the testimony of Ms. Zwerner, who said there were about 20 students in her classroom, many of whom were in her field of vision at the moment that she was shot, and I would propose that it is up to the jury whether they believe more or fewer victims exist of this crime, and so we believe we should not be required to name specific victims in either the instructions or the indictments. The argument that we did not prove age begins with a reminder of 2 things, and of course the court is aware the burden of proof at this stage is alike most favorable to the Commonwealth, but I think more importantly that circumstantial evidence is evidence. We had testimony from several parents who said that they dropped their first grader off at school, that their child was in first grade, and that they were in Ms. Zwerner's class. Ms. Zwerner testified that first graders are about 6 years old, and throughout this trial we've instructed witnesses on the record to refer to people under the age of 18 using initials, and you had several parents come in and testify using only initials of their own children. The overwhelming evidence then is that these children were under the age of 18. No, we don't have all of their specific ages, but they were first graders in Ms. Zwerner's class, and they were students attending an elementary school. And so I think that the proof of age has been sufficient to survive the motion to strike. There were 2 legal standards mentioned by defense counsel in his argument to the court. And one was that he indicated that we had failed to prove that the defendant knew of the danger. But if you consult the model jury instructions, that is not the standard. The model jury instruction for criminal negligence tells us that to constitute criminal negligence, the Commonwealth must show that the defendant either knew or should have known that the probable result of his or her acts or omissions would be serious injury or death to a child. Given that, the correct standard for the court to apply is not that Dr. Parker knew there was a danger necessarily, but that she should have known of the danger. Having said that, she did know. There were multiple warnings she received from multiple people that there was an armed student. And as I argued during the trial on several objections, whether they thought it was a toy, whether they thought it was a knife, whether they thought just the mere fact that a possible weapon is on campus should have triggered the response defined in the crisis management plan, yet it did not. So it should have known and not known. The second legal standard defense counsel left out is from the willful act definition jury instruction. And so the model on that says a willful act is done with bad purpose. That's what defense counsel pointed out, but it's with bad purpose or without justifiable excuse. And I would argue that that is the part that we rely on here. I do not argue that Dr. Parker had a bad purpose. I will concede that fact. But the law says it's either of those, a bad purpose or without justifiable excuse. And I certainly do believe the evidence has shown that she willfully omitted acts that she should have done, and that she had no justifiable excuse for that willful omission. Given that, Judge, I ask you to deny the motions to strike.
Thank you, sir. This is the defense motion, so they can have the last word. Anything additional?
Just want the court to keep in the forefront, again, the actions of everybody. Nobody acted as if there was a actual firearm. Not following school policy doesn't result in a criminal allegation. There were acts that should have been done, definitely in hindsight, but based upon information that Dr. Parker had, she did not willfully take any action, or if there was no willful omission on her part, she put these children in harm. Again, mistakes occurred, but there was definitely no criminal intent, and I would submit that her actions in not criminal. It was just that at the most it was a lapse of judgment. Somebody makes a mistake, that should not result in felony allegations or definitely felony convictions. So omitting a step in a school policy should not be considered to be a crime. She acted upon the information that she had. She took the steps that she thought were necessary. She did not believe that there was a gun. Nobody that was there acted as if they believed that there was a gun. And I'd ask that you find the Commonwealth, even at this stage, in light most members of the Commonwealth, has not established a willful act or omission. And definitely the Commonwealth, I think, is conceding that there has been no specific proof of the age of any child that was in the classroom.
Anything further before the court makes a rule on the motion to strike?
No, Your Honor.
I will be honest, we could have done that yesterday. I expected more substantial motion with case law and additional principles of law that the court would probably need to recess and consider, but we are where we are. Having considered this case for 4 days and listened to the motions of counsel, and the division of labor in a criminal jury jury trial. So in that division of labor, in those legal proceedings, questions of facts go to the jury, questions of law go to the judge. A question of fact asks what happened, and it requires evaluating evidence, such as the witness testimony and or physical proof. Questions of law ask how does the law apply to those facts, and requires interpretation of statutes, precedents, and constitutional rules. And that's kind of legalese, but breaking it down. The judge decides the question of law, which is what law applies, procedure, and runs the courtroom. In this case, a criminal jury, the jury would decide the facts, which is what happened. To give an analogy, because this case doesn't put itself well to analogy, somebody is given a ticket for speeding 70 and a 65, but they're stopped in a parking lot. The jury decides the question of fact. Was that driver actually going 70? The judge would decide, does the speeding law apply in the parking lot? So that's the way to wrap your mind around the difference between question of law and fact, which can get quite convoluted. With the question of fact being resolved by the trier of fact, which in this case is the jury, and their job would be to weigh the strength of the evidence and the credibility of the witness. And judges resolve the questions of law. And what would be put to the jury in this case was whether or not Ebony Parker is guilty. And that would be the question of fact. I do all this, say all this, because the distinction between law and fact can become convoluted, and they can be mixed. It can be a mixed question of law and fact. The Supreme Court itself has acknowledged that it can be an imperfect science of where is that dividing line, but identifying that line is important, critically important, whether or not it's a question of law or fact. Question of fact goes to the jury, they make the decisions. Question of law, it stays with the judge. And I guess for purposes of the parties' understanding, that influences the courtroom decision maker, the appellate review, how evidentiary rules are administered, and the application of precedent, which I would say there is no precedent for what's before the court of an administrator being criminally charged and tried for what has been presented and what happened that day, January 6, 2023, at Richneck Elementary School in Newport News. This court is finding that it is presented with a question of law, which requires resolution by the decision maker. The decision maker on questions of law are the judge, and whose decision is that, and my decision is that this is a matter for the court, and the court is of the legal opinion that this is not a crime, not under the common law of Virginia, nor under the code of Virginia. And the court is going to explain its rationale and ruling. With that being said, if it's not a crime under the common law, nor under the code of Virginia, should the legislature wish to make this a crime, then they will create specific statutory language to do so. When reviewing the statutory language, the court is bound by the plain meaning of that language and must give effect to the legislature's intention as expressed by the language used, and unless a literal interpretation of the language will result in manifest absurdity. So now I look at the statute. Virginia Code 18.2, 371.1. What the indictment charges here is under paragraph B of that statute. It reads, any parent, guardian, or other person responsible for the care of a child under the age of 18 whose willful act or omission in the care of such child was so gross, wanton, and culpable as to show reckless disregard for human life is guilty of a Class 6 felony. The indictments in this case don't address specific individuals, but they list students. The court finds that what has been presented to it is a mashup of legal theory, and it is not clear, based upon the plain meaning of the statute, that these facts are crimes. In the court's analysis, the court is asking, is the crime that Ebony Parker didn't follow Newport News policy and procedure, of which was put into evidence, which would have required two people to search the person of JT, either two administrators or one administrator and one security officer, of which the security officer was on site at a different school performing their duties, and the principal, the other administrator present, that's known in this proceeding, was in scheduled meetings during testing. Is the crime that Dr. Parker didn't direct a search of the child's person after being informed that the book bag was clear? Are the 8 counts of the indictment based upon the number of children in the room when the firearm went off? Are the 8 counts of the indictment based upon unfired bullets remaining in the firearm, which would be contrary to established case law as they have to be discharged? Is the delayed reunification a reckless disregard for human life? Is it the emotional trauma of the exposed child who was in the classroom? I believe the initials were KS. Is that the reckless disregard for human life? Is it the fearfulness, bedwetting, and hypervigilance of all the children in the school that day that comprises the reckless disregard for human life? Is it because JT wasn't expelled prior to January 6, 2023 due to his previous behaviors, which presumably would be in the province of the prior principals, Dr. Goodman and then Ms. Foster? Or is the crime the lack of heightened response from Ebony Parker due to her awareness of prior issues with JT? The court is unclear. And as previously stated, those legal theories do not fit the plain meaning of the statute. If they are to amount to a crime, then the legislature will need to codify it. Therefore, I do grant defense motion to strike in whole on all 8 counts of felony child abuse and endangerment under indictment CR, indictment number 24999-541-01-08. So those matters are dismissed. I want to add, my ruling today is based upon legal principles only. It is inappropriate for me to give my personal thoughts or express sympathy or concern, but it's understanding what happened that day was awful, that was agreed upon by all. The criminal matter before me does not call for me to discuss the Newport News school system or make political observations, and I will not comment on optics or engage in speculation. For the media, who has contacted this court constantly over the past 2 weeks, there will be no further comment from this court, except to commend the attorneys on both sides, Mr. Jenkins, Mr. Rogers, and Mr. Teague, for zealously advocating their respective positions and treating this forum with the utmost decorum. It is 9:46, and I did not have the jurors reporting until 10. So I'll ask the parties how they wish for me to discharge the jurors, if they want me to just tell them when they report to the room, or have them brought out and do it on the record. But in discharging them, I will remind them that no one from this court will contact them and direct them about this case. And I will ask the attorneys to please inform all of the witnesses that were to remain constructively sequestered that they are released. So from the attorneys, how would you like me to inform the jurors who are still coming in the building that they're discharged from their duties for this case?
Your Honor, I feel like we should discharge them on the record, but I would have no objection at all if the defendant or other parties wanted to leave and just do that with counsel.
Just counsel only.
That would be fine.
Okay, defense position?
Your Honor, I'm actually okay with the Commonwealth's position.
Okay, so I will step off the bench, so we'll be in recess, and then we'll discharge the jurors on the record once they all report. And to parties, please be quiet, and however you feel about the court's ruling, you can express that outside of the courtroom. This is still a professional legal forum. All right, thank you very much, and Sheriff, come get me when they're all reported. Thank you.
Please rise.
Thank you.
Court stands in recess. If we can mute the speakers.